Dr. Foster, are you still under oath?
Thank you, my lady.
Thank you.
Apologize, my lady. I was late. I thought we adjourned to 1:30, so I really apologize.
We all misunderstood you.
That was just a misunderstanding.
Yes.
Doctor, am I correct in saying that you got involved with your first interview on the 2nd of May?
That is correct, my lady.
You know that the 2nd of May was after the accused testified, after he was cross-examined, after his experts testified, and 2 of them were cross-examined. You know that?
Yes, I did.
Did you follow the trial at all?
Not daily, just in the media or the summary news or newspaper in the morning, but not closely.
Did you follow his evidence, the accused evidence?
Again, just here and there, not every moment.
If I say that there's at least an argument that the accused was not a good witness, and that the experts that testified before you started your report, they weren't good, do you think that would increase his anxiety of the position that he found himself in? That is not going well in the case?
I don't know.
But let us look at it. I'm an accused. It's not going well for me. I now see the psychiatrist. I must be anxious. He must help me.
I don't know how you perceived his case as progressing.
Can I also tell you that during cross-examination, at stages, he would answer by saying, I don't know where you're going. I'm fighting for my life. So that was his intention with his cross-examination. I'm fighting for my life. Did you pick that up, that he's fighting for his life?
I did hear that was said.
And in your interview with him, he's now fighting for his life?
No, he didn't say that to me.
Okay. So, am I right in saying then that you had 2 interviews, and that was on the 2nd of May and the 7th of May?
That's correct.
And that then includes the interviews with the people that you mentioned at page 2?
No.
Right.
No, those were on different dates.
Were those
they weren't all on the same, those 2 dates. Okay. Those dates of interview, my lady, are the dates I interviewed Mr. Pistorius.
And the other people you interviewed?
On different dates.
After Mr. Pistorius?
Yes, after Mr. Pistorius.
Okay, well,
after the first interview with Mr. Pistorius.
Yeah. Okay, so let us just get that, please. You started your first involvement in the matter is your interview with Mr. Pistorius on the 2nd of May.
That's correct.
And then your interviews with the rest of the people?
I interviewed the Mrs. Binge on the 2nd of May as well.
Yeah.
If I may just refer...
Yeah, no, please do.
Lady in my file... On the 5th of May, I interviewed all of the others. That would be the sister, the manager, the friend, the brother, and the coach. On the 5th of May, and then on the 7th of May, I interviewed Mr. Pistorius again.
Okay. Now, Can I ask you, Doctor, what is the purpose of your report?
To bring psychiatric factors to the court's attention that may be of relevance to the court for the purpose of conviction and, if required, of sentencing.
And those psychiatric factors you bring to the attention of the court as factors that may have affected his capacity to act in accordance with his understanding of wrongfulness at the time.
Yes, that it is a possibility that the court may use it.
Yeah. Now, you have said that, and if I repeat questions just because I got up without really having had time to go through your report, but so excuse me if I repeat certain things. The fact that you made a finding of general anxiety disorder, you have indicated that that disorder is relevant to the facts of this matter and his defence.
It may be relevant to the facts of the matter and his defence, depending on the court's decision about the facts of the matter, and I'm not privy to that.
Yeah. No. That I understand, but let us just deal with his defence. In terms of his defence, it's directly relevant.
Yes.
Yeah. Good. You've also, and that I picked up, you also said he's suffering from a general anxiety disorder, and that is worsening.
Yes, I believe it is increasing in intensity.
Increase. Then, you said for sentencing purposes, and I just, when you mentioned that, for somebody that suffering from general anxiety disorder and would possess guns, that would make him a dangerous person.
Yes.
Yes. And having done matters before, I'm sure that you'll also agree that that a person suffering from a general anxiety disorder would be a danger to society if he has access to a gun.
Yes.
Then you also would agree that, can I ask you that, this question, PTSD, post-traumatic stress disorder, people are being referred when they indicate that they suffered from post-traumatic stress disorder and that affected their ability to act in accordance with their understanding of wrongfulness. They are referred for observation, am I right?
They have been referred for observation in the past, that's correct.
But that's also general anxiety disorder and post-traumatic stress disorder are the same kind of disorders.
They are related disorders,
Related.
yes. They are both fall under the category of anxiety disorders. Yes. Post-traumatic stress disorder is perhaps a more specific anxiety disorder that follows on a stressful incident. Generalized anxiety disorder is more pervasive.
Yes. No, that I have, and that is my argument. In PTSD matters, they get referred, and my argument would still be that this accused should be referred for observation on your finding of general anxiety disorder, being relevant to his defence.
There can be no harm in that, because certainly the court would get benefit of another opinion, certainly.
It goes further than that, and I'm sure you'll agree with me. I say it with the utmost respect, but the court really does not have an option in terms if one reads the act. If one reads the act, the court shall, and the case law would support that. that the court shall refer.
Lady, that's not what the law says. It says there must be a mental defect and that the defense is that it influenced the capacity, that he lacked the capacity to act in accordance with right or wrong. That's not the evidence. It's not just a disorder. It's a combination between the two. And I can read it to the court. I have section 78 here. If I may just read it in full.
Yes, please.
It says a person who commits an act or makes an omission which constitutes an offence and who at the time of such commission or omission suffers from a mental illness or a mental defect which makes him or her incapable of appreciating the wrongfulness of his or her act or of acting in accordance with an appreciation of the wrongfulness of his or her act shall be criminally responsible.
That's 78.
Shall not be criminal. That's 78.1. And then 1B says, whenever the criminal responsibility of an accused, that's one of the two factors, with reference to the commission of an act or omission which constitutes an offence in issue, the burden of proof of the party who says it shall be on him, and then the important one, sub 2, if it's alleged at criminal proceedings that the accused is by reason of mental illness or mental defect or for any other reason not criminally responsible for the offence charge, or if it appears to the court that criminal proceedings that the accused might for such a reason not be so responsible, the court shall, in a case of an allegation or appearance of mental illness or mental defect, or may, in other cases, direct the matter be inquired and to be reported on. So it gives you the two legs. It gives you a mental disorder or a mental defect, and that must make the person incapable of appreciating the wrongfulness of his act or incapable of acting in accordance with such an appreciation. Those are the two legs, and that's not the case presented. So when it's put that on our evidence he must be referred and the court has no choice, that's not what section 78 says, my lady. Definitely not.
May it please the court? This is argument on an application that I haven't even brought yet, but
No, but it's a statement put, my lady. That was the problem. That's the law, and that's what I objected against, not the application.
I don't agree, because one has to go through the evidence. When we started, I asked Dr. Foster, as somebody that's been at Sterkfontein for years, having dealt with 77, 78 and 79 for years, has vast experience. One should read into act in accordance, one should read diminished responsibility, because that should be read in. Now, if that is diminished, it's not incapable only, it's also diminished, then a person should be referred. But, my lady, it goes further. It says, if it appears to the court that the accused might, for such reason, not be so responsible, if it appears, the court shall. And the case law, I'll get to it when I deal with the application. But, my lady, what I did is I asked the doctor if PTSD people get referred. She said yes. I asked if PTSD, post-traumatic stress disorder, and general... lady, that's my phone. I will never forgive myself for that. I can only beg for that you forgive me for that. It was my phone. I was making phone calls during the break and I forgot. Won't happen again.
Accepted.
And
promise it won't happen again.
And I'm embarrassed enough.
Just.
Whatever the court does cannot change my embarrassment, I feel.
Yes.
But if I can carry on with my argument, I then linked PTSD with generalized anxiety disorder. PTSD patients get referred. General anxiety disorder is the same kind of disorder, and should
So
also.
it's related, I think.
It's related.
Yes.
And therefore, if the diagnosis is made, the court doesn't have an option, and I say it with respect, but the accused should be referred. And I'll get to the case law, but what we're dealing with now is we're dealing with cross-examination. I was not wrong in my statement.
Yes. Mr.
There are two answers to that, my lady. First of all, may I, Mr. Nell reads diminished into subsection 2.
Yes.
May I read to the court what diminished is? It's in subsection 7, where it says if the court finds that the accused at the time of the commission of the act in question was criminally responsible for the act, but that his capacity to appreciate the wrongfulness of the act or to act in accordance with an appreciation of the wrongfulness of the act was diminished by reason of mental illness or mental defect, the court may take such diminished responsibility into account for sentence purposes. And in the commentary to the 2A, it deals with sentencing. He brings that now back to inability, incapacity to appreciate. And what he does in putting the statement is oversimplify it and say, but post-traumatic stress disorders get referred. It's not post-traumatic stress disorders. Post-traumatic stress disorders having the effect of incapacity of appreciating the wrongfulness. Every person with that cannot be with a post-traumatic stress disorder does not go to Sterkfontein. It's the one, and we can't leave out the second part, which makes him or her incapable of appreciating the wrongfulness. And the statement put was ignoring that, just say, that's how it must work. And I put it to you, that's how it works. And that's what I objected against. It is contrary to the provisions of Section 78, 1 and 2.
In other words, you're saying it's not an allegation.
Absolutely, my lady.
There must be an allegation first.
Absolutely, my lady.
Yes.
That's why I objected.
Thank you.
If I respond to it, it's more than an allegation. It's calling a psychiatrist to say, I've made a finding. It's more than an allegation, my lady. If there's a psychiatrist giving evidence that the psychiatrist made a finding, a diagnosis of generalized anxiety disorder, and in evidence, the psychiatrist indicates that it's relevant to the accused's defense and could have played a role and should be taken into account by the court. It's way more, with the utmost respect, than an allegation. It's evidence that's been led. I know that Mr. Roux would say, please don't take it in that so serious. We never meant it to be this serious. But it's a factor. It's before this court. We have a psychiatrist that made a finding, a diagnosis. Otherwise, my lady, with the utmost respect, why was this placed before you? It cannot be placed before you to say, take something into account. What? It's a psychiatrist. She makes findings on mental defect. And the defense decided to lead it.
So you are saying this generalized anxiety disorder
Yes, ma'am.
falls under a mental defect.
Yes, ma'am.
Is that what the evidence is?
Yes, that's what I'm saying.
Yes. Because if that is the evidence, then you have every right to put it to the witness.
Yes. Thank you, my lady.
But is that the evidence?
Yeah, that's what I'm saying. It's a disorder. May I get something
Yes,
from...
yes, yes.
from No, it's not. It's a disorder, my lady, and if it's a disorder,
Because I think that too.
yeah, a mental defect.
Yes, it's
Let me say, a mental. This is a mental illness.
it's
because
a mental
it's a
illness or mental defect.
Yeah, I'm saying it's a mental illness. It's been diagnosed as a mental illness.
But is that what the witness has said?
Well, my lady, the witness it indicated that it's a psychiatric condition. But, my lady, a psychiatric condition, as in terms of the DSM-5 handbook that I'll go through with Dr. Foster now, Diagnostic and Statistical Manual of Mental Disorders, been listed as a mental defect.
As a mental illness?
As a disorder. As a disorder. If that's a disorder, it's a mental illness. That's what I'm saying. That's my argument.
Well,
And then
I'm not quite sure I follow. What do they say about this mental?
I'm saying it's listed. I'm saying it's listed in the DSM
Yes,
5 as a disorder.
as a disorder.
Yes. And a disorder, I'm arguing, is a mental illness.
Yes, but where do you get that from?
May I ask where I get it from, Elaine? That's, milady, it's a mental disorder. If it affects his capacity to act in accordance with his understanding of right and wrong, it should be looked at.
But that is not the allegation, and that's not the evidence of the witness, unless I misunderstood her.
Milady, if that's not the evidence, that's how I think that's the evidence. Dr. Forster said it could have affected his ability to act in accordance with his understanding of wrongfulness. I asked her before the break, she said that. She said, if that is so, if we get that answer then, with the utmost respect, milady, if we get the answer that this disorder would have affected his ability to act in accordance with his understanding of right and wrong, that would then be the end of it. And I think that's the answer I had.
It doesn't even ring a bell. Did you write that down?
My colleague gave me her notes, where the answer is.
What was the question? Sorry.
I asked if the psychiatric factors or disorder would play a role in his understanding of right and wrong. The witness answered, possible that these psychiatric factors may play a role in his capacity to act in accordance with his appreciation for right and wrong. The factors are directly relevant to his defense.
Thank you. Thank you very much.
As a court pleases.
Yes. Mr. Rui, you still want to say something?
The evidence then, what I submit, first of all, you can't take the DSM disorder and make it a mental disorder. Secondly, the witness was clear in her evidence to say she's not saying that he could not appreciate the wrongfulness and could not act accordingly. It's a factor to be taken into account. When you're very small and you get attacked and the court must consider self-defense, it's a factor. I'm just using a physical. So you can see when a person is very nervous, at the end the court will take that into account. And that's all. But what the state's doing, it's elevating the answers to something else. And it's saying, contrary to the witness's answer,
Just hold on.
that it was an incapacity. That's not a witness's evidence. She specifically denied it. But what I objected against, and you can go through the questions again and get clarification, what I objected against was the statement made to say, this is what it is. It is now an incapacity to act in accordance. And I say that's not what the Act is saying. And I've no difficulty if Mr. Nell would put the questions to get clarity, and I think he should do so. The statement was not in accordance with the Act.
Okay. Thank you. Yes, Mr. Nell?
Milady,
You want to rephrase it? Because we can go on and on about this for the whole day.
we will go on and
Yes.
I'll rephrase it.
Yes.
Let me ask you a question, Dr. Forster. The diagnosis of generalized anxiety disorder, may it have an effect on the accused's capacity to act in accordance with his understanding of right and wrong?
No. I think that, if I may be helpful, your lady, I think that it is clear that Mr. Pistorius has a psychiatric illness. He certainly was able to appreciate the difference between right and wrong. But it may be that his ability to act in accordance with such appreciation was affected by this generalized anxiety disorder. However, that would again depend on the facts of the case, which is for the court to decide.
Good. Dr. Foster, then, just from the way I interpret your answer is the, may we call it GAD,
Yes.
generalized anxiety
It's
disorder. May we call it GAD, my lady? The GAD may affect the second leg of 78, his ability to act in accordance with his understanding of right and wrong.
But, yes, but this has to be linked to the offence.
Yeah, no, that it has to be linked to the offence.
Yes.
But I am now dealing with the fact that I asked you what the purpose of the report is, and you indicated that is to indicate to court certain psychiatric factors that may be relevant, and you said for conviction and sentence. Now, relevance for conviction means that it affected his capacity to act in accordance with his understanding. Otherwise, that would not have been mentioned by you.
That's correct.
Well, if that's the answer, then it's the end of the argument. If you're willing to say to this court that your diagnosis may have affected his ability to act, then I go back to what Mr. Roux said before Mr. Roux objected. The way I understand 78, the court shall refer.
Again, the problem is it depends on what the offence is. So, perhaps to summarise, if I may, to put that if he was afraid that there was an intruder, then certainly having a generalised anxiety disorder would have affected the way he reacted to that fear.
Yeah. And that is so relevant to his version. And I'm not saying he's wrong. His version is correct. I'm not saying that. I'm just saying that the defence, in having called you as a witness, have now caused the court to refer the accused. Because on his version, there's no other option.
On his version,
Yes. Yeah.
it is relevant.
Yeah. Good. Now, that will be my application, my lady. Based on what the witness said, I will go through a report because we'll have to excuse her. But I'm bringing that application based on this witness's evidence that this court will not have an option but to refer Mr. Pistorius for mental observation for 3 days.
In terms of?
Section 78(1) and 78(2), my lady. 78(1)(b), to be more direct, and the procedure is in 78(2). My lady, I've had, in the very little time that I had available, just read all the case law referred to in the Commentary on Criminal Procedure Act, the TOI, and that just strengthens my application, my lady, that the court shall. It goes so far, my lady, as in the matter that I know well, is versus Moki. That is 1992-1 South African Criminal Reports 430 Transvaal Division, where an accused pleaded guilty, but during evidence and mitigation, he said, well, he cannot really remember what happened. The court said, by him saying he cannot remember what happened, he should be referred, because it gave a reasonable doubt as to his mental state, that the court ought to have ordered an investigation into the accused's mental state. My lady, the basis of Section 78 is for the court really to satisfy itself of the mental state of the accused. Now, Mr. Roux is 100% correct. The onus is on him. But it started with it today. Because otherwise, my lady, if that's not the intention of calling a psychiatrist to say that somebody suffered from a mental disorder, then I don't understand it. There must be some reason why Mr. Roux decided to call this witness. It might be the third defense that we have, but it is a defense. And my lady, the Act is so clear on it. To ensure that the court appreciates the mental capacity of the accused to act in accordance with his understanding, the Act made it shall. I'm sure, my lady, that I've now brought this application, but the court would know that I received a report when Dr. Foster walked into the witness box. I've had an hour to research. I'm fairly convinced. So, at an appropriate time, and that would be just after Dr. Foster's evidence, I'll bring the application proper. But my reasons as set out now, my lady, will be my reasons.
In other words, you're going to proceed with
as far as I
the
can,
witness?
and then I'm going to ask that the witness be, well, for lack of a better word, provisionally excused, my lady, because we can't keep her here. And then I'll bring the application. As a book reason.
This was just a preview.
My lady, this will be my argument. Being a preview, my lady, I feel strongly about it, and I just don't think that there's a way out. I'm sure it wasn't the intention by Mr. Roux to have his client referred, but it is. It's in the report.
Yes. Please proceed.
As the court pleases. Doctor, you've heard everything, and I know you've been in courts hundreds of times, so you understand I'm going to deal with some aspects of your report, and then we might have to call you back later.
I do understand, my lady.
There's just one general aspect that I know you've dealt with in the past. If someone would, even in anger, kill his partner, very upset, kill his partner, but just after that, that person is capable of deep remorse for what he's just done. That is general, isn't it?
Yes, that's true.
So, and I know we've dealt with this matters. You saying we were in matters together.
That is true.
Where, in a fit of rage, you would kill your partner. Then, when you realize what I've done, you'll have real deep remorse for what you've done.
That's correct.
And in all the matters that you've dealt with, excluding the psychopaths, excluding them, normal people, that's what's expected. Deep remorse after you've done something that you think I should never have done.
That's correct.
Good. Now, the also interesting, Doctor, is that the way you framed your last sentence, he's certainly remorseful about the events. What would that be?
He feels remorse about having caused the death of Miss Steenkamp.
Not having killed her. He's never said to you, I'm so sorry I killed her.
No, I don't have a recollection that he didn't say that.
But do you have a recollection, I'm so sorry I killed her? Or did he do like he did in court. Caused the death. I'm sorry, I caused the death. There's a difference.
There probably is a legal difference, my lady, but certainly from a psychiatric perspective, he is certainly aware that he fired the shots that caused Ms. Teerkamp's death, and that he is distressed about her death, and that he feels guilty that he caused her death. So whether he says, I fired the shot or I caused her death, that's maybe a legal difference, but not particular psychiatric relevance.
Now, and I know from past experience that you have testified before in matters that if somebody wants to rely on the fact that, let's use that he acted automatically. Let's start there and we'll build from there. If somebody wants to rely on the fact that he acted automatically, you would look for events leading up to this shooting, let's use a shooting, and events that followed on that. And you would say that if there is planning, then one can't really rely on being automatic, having acted automatically.
Yes, there's no question in my mind that this is not a defense of a sane automatism, my lady. So there's no history that he gave of any emotional stress following an argument or anything in that line. There's no question that he perhaps says he has a period of amnesia at all for events, and his reaction following the death is appropriate. So this doesn't fall into that category of conditions at all.
Yes. No. I never thought you would say that, but let us build on that. You know the fact that the accused indicated to you that also that he heard a burglar in his or intruder. He thought there was an intruder.
That's what he told me, yes.
He then armed himself.
Yes.
And he approached the danger.
Yes.
To sort the danger out.
Yes.
That's it. Now, Doctor, having been involved in lots of matters, when he armed himself, he at least then foresaw the possibility that he might have to shoot. Because otherwise, why would he arm himself and approach the danger? Am I right?
Well, he must have.
He must have foreseen the possibility that
he may have to shoot.
And he then went further and he did shoot.
We know now that he did shoot, yes.
So, just by arming himself and approaching the danger, just on that, it already indicates that he acted in duress provincialis before he got to the door. And that when he fired, that completed the duress provincialis. So you agree with me if I say that he foresaw the possibility that he might have to shoot when he armed himself and approached the danger?
Yes.
You see, that brings me then the fact that he suffered from GAD or that he was anxious. Did you follow the evidence about him not finding out if Riva was safe and if she was still in bed and so on? Did you follow that?
As I said, my lady, I didn't follow the court proceedings in detail at all. I think that situations would have to be put to me. That would be better.
Yeah, and I'm not going to if you haven't followed it, but you see, I think you cover it in the sense that you say his personality is. You put it better than I could. What did you say, Doctor? That would rather approach danger, more likely to respond with a fight response rather than a flight response.
That relates to his generalized anxiety disorder.
I see.
Yes.
Well,
I think that is on,
I found
on
it
the
page
bottom
9.
of page 9,
Yes.
the last sentence.
I found it And that made me just realize that if we have a person suffering from GAD with a personality that he would rather approach, that he would have a fight response and not a flight response, that makes him even more of a danger, because he gets anxious quickly and he approaches and he wants to fight that, whoever he feels is threatening him. Am I right?
No, that's not my evidence, my lady.
What's your evidence then?
My evidence is that the fight and flight response relates to his generalized anxiety disorder. And because he has, some individuals will go towards a conflict situation and some will move away from it. But one has the added vulnerability of being unable to run away. And you have no choice but to fight rather than flight. So I've related it to the generalized anxiety disorder and his specific vulnerability.
But you see, it goes further than he was on his stumps. He armed himself, he walked 5 meters towards the danger on his stumps.
Yes.
He turned right, he walked another 2 meters on his stumps before he got into the bathroom. Whereas him and Riva could have escaped out of the main bedroom very, very easily without him having to approach the danger. Is that how an anxious person would act?
Yes, some anxious people do act by approaching danger, especially if they think they can't run away. So I think it would be an expected reaction.
But he could run away. I mean, the runaway option was there.
He couldn't really run away. He's not mobile on his stumps.
Well, they could get away through the main bedroom. But on what you just said, when we started, you said that somebody suffering with GAD with a gun in hand is a danger.
Yes.
Lady, may I just be granted the opportunity to page through my notes? The one interesting aspect I picked up about the where's that? Right. One interesting aspect I picked up is in the way they describe generalized anxiety disorder, is that they've mentioned at page 223, but that deals with the generalized anxiety disorder. Many individuals with generalized anxiety disorder also experience somatic symptoms, sweating, nausea, and diarrhea. And this is what you pick up.
He had the sweating and
the nausea.
The nausea, but
not the diarrhea. Sweating and nausea. So that one shouldn't really relate to him feeling remorse, and that's why he retched and sweated, because it's one of the aspects that one would expect if somebody suffers from GAD.
Yes, certainly one will expect those kinds of symptoms with the generalized anxiety disorder. And then when having to relate a distressing event, one would expect to see those symptoms coming out. Certainly in terms of looking at that symptomatology, I did not believe that they were feigned, but that they were genuine.
Doctor, I remember when we started to ask you what the purpose of the report was, and you said, so you included aspects of sentence and merit in your report.
Well, I believe that my report could be used by the court for whatever purpose the court wishes to use it.
But why would you, if one deals with the incident that happened on the morning of 14 February, why would you mention that he's now suffering from depression?
he is suffering from depression, so it would be part of the psychiatric evaluation.
That is now suffering from.
Yes.
But as far as the incident's concerned, that the court cannot really take that into account as far as that's concerned.
No, that's his current mental state. So in seeing him now, he is an individual that is currently depressed and on treatment.
And the fact that you raised remorse, why did you do that?
Because he often said that he felt so guilty about Ms. Steenkamp's death. It was a recurrent theme.
May I just ask you if you haven't had access to the case docket in this matter?
No.
You haven't had access to the investigating officer or the state or any?
No.
As far as the accused and his version is concerned, what did you have access to indicate to you what his version was?
His version?
Yeah.
As he gave it to me.
He gave it to you?
Yes.
Okay. You never had access to his bail application?
No.
And did you rely on what you've seen on TV or read about the matter in the media?
No.
You relied on what he gave you?
Yes.
Okay. You weren't able to refer the accused for any other assessment, psychological assessment, and so forth?
No, I had available to me a report by Dr. Richard Holmes. He is an industrial psychologist, and he did have an aspect of it from a clinical psychologist. So I did have that available to me, but I didn't have any direct report that I had obtained, for example.
Okay. Now, during your interviews with him, did the case and the status of the particular case form part of this interview? Discussed? What might happen to him?
No.
His evidence?
No.
The fact that he has more than one version?
No, those are court roles, not mine.
I'm just asking in your expert interviews with the accused. So, the accused feels guilty, you said, or feels guilty that it caused Ms. Steenkamp's death and that he's remorseful about it. He wanted to shoot an intruder. Is that what it said?
That's what he told me, yes.
Okay. And that his deep remorse is because it wasn't the intruder that he shot, but Riva.
Yes.
Thank you. Milady, this must now be an opportune time for me to ask that we adjourn, provisionally excuse Professor Foster, that I bring the application, whatever happens thereafter, that we call her back and or not. But I feel that I should bring the application, and I'm intended to do that.
Yes. Do I get it correctly? You're not quite finished with...
Not at all, my lady. It will all depend if the case is referred or not. Okay. If the case is referred, that's the end of it. If the case is not referred, I might continue.
Thank you very much. Yes,
With respect, my lady, you can't deprive me of a right to re-examination because I fully understood what the witness was saying to you about the finding of the facts with reference to the section I don't want to say it argued in front of this witness. So if you can't just unlimited answers then bring an application without giving the defence the right to ask Dr. Foster about certain of the answers and to explain it, what was actually meant by the facts of the case. And I may answer, I would not want to argue it in front of Dr. Foster because I do not want to be suggestive.
Mm-hmm.
So, and I believe that coming to re-examine...
You want us to excuse the witness for now?
Thank you.
You are excused for now. Depending on what ruling I grant, you may have to come back to the witness then. Today.
Today. I will wait outside, my lady. Thank you.
Please.
And I did the reason was this, that she said with reference to a factual finding, and I can think, and I can surmise this, that if the factual finding is that he was delusional because of his absolute disorder and that there was no window opening and there was no toilet slamming, and facts like that, and there was no one in the toilet, he just fired shots into the door thinking there was someone in it, and all those factors, then of course, my lady, then we come to a disorder coupled with the second leg, and that is the inability or the incapacity to understand, distinguish between right and wrong in relation to this disorder. And that's all the witness was saying, depending on the facts. If, however, the facts were different, that he was acting, that he was going there was in fact a window opening, there was in fact a toilet door that was closed after he heard the slamming, then it's very different. Then it has nothing to do with the second part, the second requirement, Section 78. And I believe that you should not, rather, hear the application without giving us the opportunity to do a re-examination and to say, what is it that you meant with that, and the factual position that the court must find? Because that's been my understanding all along. If the facts are very different, and if the facts show that this order also culminated into an incapacity, then of course it's a Section 78(1) classic. But if that's not the factual position, then we simply have a factor, a disorder to take into account when considering the conduct of the person in considering the merits, which is very different. It's when a person is very small and he acts in self-defense. When a person is a woman, you take it into account. It's a woman against a strong man. All those factors, but they have nothing in common with an incapacity. And that's the objection that we have in the state bringing this application based on limited facts and by depriving the defense of the right to ask the necessary questions after cross-examination to bring to the court's attention what's actually said by the witness in context, and that's all we're saying. So if he brings the application on this basis, we will simply ask for the witness to be called on that basis that I can ask her those questions. So we're going in the wrong procedure. What Mr. Nell should do, he should finish his cross-examination, allow us to have re-examination, and then if he believes there's merit in an application, then bring it. But not halfway through on our facts, my lady.
Mr. Good lady, this is a strange application. Mr. Roux called the witness. The witness testified. I'm busy cross-examining the witness, and the witness made certain concessions, gave a view. Now Mr. Roux said, I want to change the view of my witness. But my lady, you can't go even further than just reading a report. Page 9 of a report indicates that the factors, the levels of anxiety, the GAD, were all operating at the time of the offence under discussion and would have compounded to Mr. Pistorius' physical vulnerability and the additional pressure of perceiving his environment as hostile and unsafe. My lady, what we're dealing with here is Section 78. The question is not the facts. The question is not what the facts are. If Dr. Foster interpreted the facts rightly or wrongly, the fact is, is there a mental illness that may have impacted on his ability to act in accordance with his understanding of right and wrong? That is it. The witness already answered that. If Mr. Roux re-examines for 3 hours, she's answered it already, saying, I know his defense.
But he has a right to re-examine, hasn't he? It doesn't
Yes,
matter what the witness has said.
No, yes.
If there is...
But he's saying he wants to do it now.
Yes, why not now?
My lady, I'm thinking about it again. If I have not finalised it, because I would have liked to finalise my cross-examination after the application. But if it's important for the application and it would enlighten the application, in fact, we should take into account, I don't have any problem if Mr. Roo would re-examine the witness now. I will then bring an application to...
But you did say you haven't finished with the witness.
Yes. But I wouldn't have a problem if he re-examines at this stage. And I bring it application later. I don't have.
I think that's how we should do it.
Of course, my lady, that's important. He must finish his cross-examination. Of course, you don't get a re-examination and re-examination. Let him cross-examine. Once he's concluded the cross-examination, our re-examination, he can properly bring the application. We will oppose it. And then we have all the facts available, the facts that came at them. Evidence in chief, cross-examination and re-examination for you to properly consider the application. Just on one point, and that's the theme that I see here. The reports referred to as all supporting the application. I invite the court to look at this report and find any reference by a psychiatrist experienced in references to say at any place that he was incapable of appreciating the wrongfulness or could not act in accordance. That's not what the report is saying. Mr. Nell refers you to page 9. I ask you to go to page 9 and we can read that paragraph to understand my difficulty what he's doing. He says, it's there, he says, it's there that he's incapable of appreciating. It's not there. That's not what the witness is saying. The witness is simply saying the court must take his condition into account depending on the facts. And as I've said before, if the court's finding is that the facts are that he is so paranoid that there was no window opening, there was no toilet door that was closed, of course, my lady, it's a 78. But those are not the facts, and that's the only thing that the witness was saying. It's for the court to decide on the facts. But this whole report does not, at any of the 10 pages, make any reference to the most important leg of what the state submits now to you, and that is an incapacity of appreciating wrongfulness or to act accordingly. That's not the report. And all that it is to say, should there be facts before the court on the factual content, because the witness is not involved in looking at the facts, that he was delusional, that he was so under this paranoia that he heard windows opening and the window was closed according to the photos, and he heard doors slamming and the door was open, then of course it's different, because then you have to reconsider to say what's going on in this matter. But those are not the facts, and all that the witness was doing was not to usurp the powers of the court. Say, that's for the court to find on the facts, and if that is what the facts show, then of course that is so it's for the court to consider. But we can't go halfway. Let the state finish the cross-examination. Let us do in proper time, in a proper place, the re-examination. Let him bring the application and let us oppose, and then the court can, on all the facts, come to a just finding. I don't think we should go halfway.
Lady,
Mr. Nell, is there a problem with finishing with the witness? And what is the problem, if there is?
the problem is, my lady, that I would want to know if the court referred the accused or not.
Pardon?
I would want to know if the court referred if the court decides to refer Mr. Pistorius for observation, then I don't have any questions. But if not, my lady, then I have questions. But
yes, but I'm not quite sure I follow.
why can't I finalise it now?
Yes, that's what my problem is, or my question is.
My lady, I would be guided by the court's decision to refer or not. And I would also understand what the importance of this witness is, having heard the court's judgment. But, my lady, we've now argued up and down, and I don't want to waste court time. I will indicate that I have no questions. Mr. Root can cross-examine, and I'll bring my application. It won't prejudice me.
I'm not sure. Are you saying now you don't have any more
I don't
questions?
have more questions.
You sure about that?
But I'm not that sure about it. I've been guided by a psychologist sitting behind me, and I will need to just confer with them.
Because I don't want to be unfair to you, Mr. Nel.
Yeah.
If you need more time to reconsider this, I'll give you time.
I think I need more time to reconsider.
Yes.
And may I ask that the court adjourn for 10 minutes? I will then be in a better position to indicate to you if I have further questions and if I need time to consider further questions.
Court will adjourn.
May it please the court, my lady says this. I accept that I'll have to finalise the cross-examination, whereupon Mr. Roux will then have an opportunity to re-examine. I'm then at the predicament, my lady. I would need time to prepare the final cross-examination, and I kindly request that we adjourn until tomorrow for that purpose.
Yes. Mr. Roux?
No submission, thank you, my lady.
I have asked the witness if she's available, and she kindly indicated that she is.
You will be available?
Yes, my lady.
Thank you very much. Thank you, Doctor. Then we'll resume tomorrow at 9:30 in the morning.
As a good please.